Je vais parler en anglais, et je dis que c'est la nouvelle norme suisse. Les germanophones vont plutôt à l'anglais qu'au français. Pour moi, c'est beaucoup plus facile parce que notre travail à l'ONU, ça se fait beaucoup de fois en anglais. Et pour moi, la terminologie francophone française n'est pas accessible autant que l'anglais.
D'ailleurs, j'en profite pour rappeler qu'il y a des casques de traduction simultanée ici. Si quelqu'un veut la traduction vers le français, il y en a encore. Pardon.
My intervention was announced as a clôture, as a closing. I think it's more opening up to another perspective. We have heard a lot of perspectives about women in the media, women in the digital world in general. And I will take a next perspective to complete what you have heard. It's taking back a step from the operational work. It's going more in this universe of international standards and discussions. It's only an introduction. We don't go to much details. I hope that you will have some questions which can be more concrete. I just want you to listen a little bit to this space which is there, this legal space which can be used also in very concrete and operational work. I will talk to you about the international human rights system and its potentials for protecting media freedom and democratic spaces, also in the digital world. Secondly, I will talk about the perspective of gender discrimination at the international law level. We already heard about the Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW, which has a committee I'm part of. And then thirdly, I would like to talk to you about the CEDAW's obligations for states and entry points for addressing women's discrimination in digitalization and the media. The international human rights system, you certainly have heard a lot about it. It's not only about individual rights like the right to freedom of expression. It's a whole system which tries to protect the space, the personal space of citizens all over the world. There are universal and regional human rights conventions, and they are widely ratified. So since the foundation of the UN in the 40s, there was a trend to set standards on how states should treat their citizens. And this has resulted in a series of human rights conventions which are really legally binding. States are obliged to respect themselves, but also protect citizens from violations and also put energy in the fulfillment of such rights and freedoms. So it's not only about just not violating rights for state authorities. It's to take an active stand in making policies, in changing practices, in changing laws, with a view to realize these rights. All the rights must be guaranteed in law and practice without discrimination. This concept of discrimination also includes the basis of sex. But there are other grounds which are not allowed to distinguish. They don't allow distinctions in the legal framework on basis of race, on basis of origin, on basis of religion and beliefs. There are a lot of conventions, as I said, but there is also a constant debate on how to develop these rights further. We call it soft law. There are a lot of guidances a lot of studies made, particularly in new areas where human rights are under pressure, such as digitalization. So there's a lot of numerous texts of resolutions, declarations, which are forming a basis for future legal obligations. And it's always difficult to find our way in all these texts, in this universe of declarations and statements. We also have to say that there are a variety of accountability mechanisms at international level. It's not given to the states that they can just implement their obligations and nobody is looking at what they are doing. There are a variety of accountability mechanisms supervising with different instruments the implementation of human rights. They are either treaty-based, as our committee is, looking after the implementation of the Convention on the Elimination of Discrimination of Women, or they are, we say, charter-based. They are much more politicized. There are, the Human Rights Council in Geneva is consisting of 53 states, and they are also producing declarations, and they are treating human rights violations in a very politicized form. There are pros and cons for both, of course. Of course, we can't say nothing about the UN crisis right now. The funding situation is very dire, and this is the surface, I would say, of a deeper crisis of international relations. You certainly have heard about the crisis of international legal standards. The international rule of law is questioned. And I think this is a real challenge which is manifesting itself also at national level in a backlash of nationalism, of right-wing patriarchal ideas gaining ground, and this is very much palpable, tangible in the UN. The international rights and obligations, as I was already talking about that, this balance of obligations of states and on the one hand, and rights of individuals and groups on the other hand. These international rights and obligations are an important basis also for protecting journalists, media itself, and activists. There is an explicit right to freedom of expression, right to assembly, association, movement, which is the basis of democracy. There is an explicit right to information in the Covenant on Civil and Political Rights. There is a right to participation. And most importantly, the right to liberty and security in person, which is the basis for protecting people from violence and arbitrary detention. A lot of attention was given when the covenants, the human rights covenants were drafted. A lot of attention was given to judicial procedures and to rights in detention. I think this was also a little bit due to the fact that these covenants were drafted by this classical liberal ideas, the people who defended it, the liberal ideas. The main problem of each and every citizen is to be detained. Now we know that there is a lot of dynamics going on around human rights, and maybe the most important violators are not the states, but big companies, big power holders which are not directly linked to the state. We will come back to this later. The accountability mechanisms, they don't allow only, let's say, holding states directly accountable. They are also fora for debates. There is a lot of information produced by all these accountability mechanisms on problems, on the digitalization in the context of human rights. There's a lot of debate going on because states have to respond to an accountability committee. They have to say, explain what they are doing. They have to explain what they are not doing. And this mechanism of questioning gives a lot of publicity to many human rights violations, be it at national level, be it at the level of different topics. The UN Convention for the Elimination of All Forms of Discrimination Against Women is an old convention. It was drafted in the 70s, and you can imagine that digitalization and the current form of media that we are living is what is not really represented there. It was very successful at that time. In the 80s, 90s, almost all states have ratified. 189 have ratified the CEDAW Convention. Although often with reservations, and quite broad reservations. So there is always, we can't deny that states were not ready to accept all the content which was in that. The most important thing about international public law is that there are voluntary commitments with ratification of a convention. The states voluntarily agree with their content and say, this is a standard the state authorities have to respect. So it is, then when it is ratified, it becomes a binding obligation. And this is often not really recognized by many media people too. They think that this is just a standard which is out there in the UN, but it's, particularly in Switzerland, it's binding law. You can really call for respect, protect, and fulfillment of this law. So maybe coming back to this idea of respect, protect, and fulfill, this is also a very important thing on gender discrimination. It's not only about not respecting equality in the state actions. It's really obliging the state authorities to invest in identifying discrimination and then also in eliminating it. I said that the convention is an old convention. It talks about women, discrimination of women. The committee has in its long practice developed this term further. It tries to adapt to new trends, but you have to understand that we have 23 members from all over the world where gender is not understood the same way or everywhere. And the experts which are sitting in the committee, they are proposed by state authorities. Then they are elected by the whole group of ratifying states. 189 states are then electing the members, but still, of course, you may not have the real independent experts there. They all have their own bias and perspective from the point of view of their origin and background. So it's sometimes not so easy to get the common understanding what gender discrimination is in such a group. But I must say it's quite a lot of common basis I can see now after 3 sessions in Geneva. I see that we quite agree on many things all over the world, and that's a good sign. Maybe we should also talk about this idea of formal, substantive and transformative gender equality. In fact, traditionally, there's always, right now also, some misunderstanding. People think that if it's not in the law, then it's not discrimination. This is just practice, or, you know, this is the problem of women if they don't really take up their opportunities they legally have. It's just their private problem. But in our convention, it says it is also about de facto discrimination. And I think this was a very important basis in the 80s to talk about de facto things and not only about legal, formal equality. And another dimension was added later on. It's about structural discrimination. It's not your individual problem if you are not illiterate about digital tools. There is a whole structure, a system behind that. The discrimination, the CEDAW Convention is about all these forms, which have to be seen in a context. I was reminded that I'm talking too much. I will go on a little bit. What are we doing concretely? I think it's important to see that the states are in the international law fora. The convention is the basis. The committee is only overseeing the actions of the states. We can't act for the states, but we can bring violations and problems to the public awareness. We are 23 experts, as I said. Our task is to review progress in implementing the commitments. This means that we are regularly looking at periodic state reports that are given to us by the states. We are having a critical dialogue, which is only possible with additional information from civil society. There is an instrument of individual communications. If there is a case which has exhausted internal national remedies, it can be brought to the committee. And there is also a very important instrument which is called general recommendations. This is the tool which we could use to discuss about topics which are of interest all over the world. We're currently preparing a general recommendation on stereotyping, and this is, you can imagine that all what we have discussed here will be also in there. And I think it's a very good contribution of our committee to the general debate about international standards in upcoming topics. So, I just wanted to briefly talk about the most important four obligations and entry points which I see we can take from the CEDAW Convention. I just talked about the obligation to eliminate stereotypes. It's an obligation to eliminate, it's not just addressing. There's an obligation to eliminate discrimination against women in political and public life, including media. There is an obligation to eliminate violence, including technologically facilitated violence against women and girls. This is the newest term which is used. And the obligation to ensure education and employment without discrimination, also in the field of digital education and employment. Just very shortly, Article 5 CEDAW, which was in a way a revolution in the 70s, is about stereotypes. It's very rare that at that time, when the formal equality idea was still very present, stereotypes were really addressed in a convention. It's the only one that addresses stereotypes in that way. It says that state parties have to take measures to eliminate stereotyped roles of men and women. And I think this is, we can take this much more seriously. We should take this much more seriously, that there is an obligation at the international level. I think I have a list of bullet points. It was just what we discussed today. It's the stereotype, the standard on stereotypes gives us a leverage on asking state parties to deliver. I don't want to go to details here. There is also an article about equality in political decision-making and public arenas. We also talked about this. I think it can, the Article 7 is also a very good basis to request measures to be taken that women professionals in the media can really work, that women in politics, which are particularly targeted by discriminatory treatment, that they can have their ways to complain, and that the gender digital divide in accessing internet, which is universally huge. I don't want to go to detail there, but that this gender digital divide really has to be taken up by state parties. I don't want to go to detail about addressing violence against women. We have talked a lot about that. We are discussing in the committee also about all these forms. There is a general recommendation on violence against women, which is referring to digital spaces, violence in digital spaces. So I think there is a lot to discover there too. Discrimination, the education system and employment, we have also talked about that. I don't want to go to the detail here. Just my last slide. Let's use the international framework. It's out there and it's not used enough. It provides us legitimacy for our requests. It provides us in the civil society a common ground for engagement around all these things. It provides us with ideas, with data, with analysis, which has been made. There were a lot of studies quoted today, which are stemming from this international human rights systems. And I think human rights and women's rights standards can really help us to make all these things more visible in the political arena, on the political agenda of Switzerland and of each and every state party. It can help us also to influence judicial procedures, interpreting the criminal law in the light of international standards, which is happening every day. And I think it can also help us to make women more visible in media work and in the public in general. So I hope, in a nutshell, to have opened your mind on another perspective, the international law perspective. I think the topic is always the same. We have to engage. We don't have any other opportunity. Thank you.
Thank you so much, Erika. Is there time for a question? One question. Okay. Do we have one question?
No.
If we don't, no. Ah, Maya.
May I ask you just to explain how the UN and particularly your committee is going these days with the budget and what's going on there?
Yes, this is really the key question today for the UN system, the funding. We are not privileged. We have to bear the burden, share the burden of budget cuts with all other institutions in the UN. And there is, I must say, there is a lack of transparency how this happens now. And I think this is most affecting us, the lack of transparency. We don't know, we can't plan. And I was very positive about the accountability mechanisms, and when I started my work at the beginning of this year, everything was normal. And now we are struggling for our next session. We don't know whether this happens. We are going back to virtual discussions. A committee of 23 it costs if you want there's a lot of costs involved in interpretation. I see it's a financial burden for states, but it's also a chance. We have it, and if it's destroyed now in the next years, just because state parties think that this is not a priority, it will be very hard to build up. And I don't know how our system will look like in 4 years. And the perspectives are quite dire for the UN, I must say. Even more, we have to engage. And we have to make it visible that there is a system just scrambling now. And I think it is worthwhile to fight a little bit more and say it is important that we keep that, just for civil society also, to have this framework in place which is providing us with legitimacy and a basis for our requests.
Merci vielmals. Thank you very much. We can give Bill, give a big round of applause.